Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez from Chug Attorneys and CPAs, tuning in from our San Diego office. Please join me in welcoming partner and attorney Min Kim from our New Jersey office. Hi there, Min, and welcome.
Hey Ariana, good seeing you again.
Thank you for being here back with us. So today's topic will be part two of our deep dive into the new H-1B modernization rule. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship. So if you have any questions, please comment them below or email us anytime at info@chug.com. So Min, this rule is in effect as of last week, and in part time we went over how USCIS is redefining what it means for a position to qualify as a specialty occupation, as well as requiring H-1B employers to prove that there is a bona fide job offer for the foreign worker. For a deeper analysis of these issues, you can find the full video on our firm's YouTube channel, LinkedIn page, and other social media platforms. So, okay, Min, let's get into it. In order to avoid making this into a three-part series, let's get right into it and start from where we last left off. So, I believe we were talking about the differences between a staffing company versus a consulting company for H-1B purposes. Can you explain once again why these differences are so important?
Yeah, well, I mean, I suppose they're important because the H-1B modernization rule changes the focus on what to look for in either approving or denying an H-1B case, depending on whether the U.S. company is considered a consulting company or a staffing company. In looking at the overall factors, if USCIS believes that the H-1B petitioner is a staffing company, then rather just taking the H-1B staffing company at its word in accepting its job requirements for the position it wants to sponsor for off-site employment, USCIS instead will look into the job requirements of that end client in making the determination whether that occupation is an H-1B role.
Right, you touched on that in last week's session, and we wanted to further unpack that issue today. So, this is a total game changer when it comes to the H-1B program, isn't it?
Yeah, it certainly appears so. As it relates to those companies whose business model is to have their employees deployed to work at the sites of their third-party and client companies. Historically, in practice, but also kind of built into the overall definition of the H-1B visa classification is how we only looked into what the H-1B petitioning company required in terms of minimum education and minimum years of experience. Now, in order to help those adjudications along, stakeholders have previously tried to show USCIS what other companies within their same line of business typically required in terms of education, but it's always been what the H-1B petitioner has historically required.
So, therefore, there was no need to look at the job requirements of the end client because that wouldn't be relevant. Am I correct? This H-1B position belongs to our H-1B staffing company. So, USCIS should limit their focus on the job's requirements at the staffing company only.
Yeah, exactly. Because what other entity knows the position requirements better than the actual hiring employer? But over the years, USCIS has sort of chipped away at this rule and attempted to expand the scope of its inquiry into what the end client requires. And now we have the final iteration of that in the form of this H-1B modernization rule.
I follow you, Min. But let me put on my USCIS cap and play devil's advocate here for argument's sake. Wouldn't you agree that the years of chipping away, as you put it, is reasonable on the part of USCIS? In the consulting space, my understanding is that as part of the negotiations, the end client and our H-1B staffing company will talk back and forth in identifying what type of resources the end client company needs as part of its staffing project. Maybe those same requirements, for example, workers assigned by the staffing company must all possess at least a bachelor's degree in engineering. Those same requirements might even make it into the final signed version of the MSA or work order that finalizes the engagement. So, given that, isn't it reasonable and maybe even best practice for USCIS to look into the job requirements of the end client? I mean, after all, it is that end client that is going to receive the beneficiary work product.
It's certainly sound logic, and probably the justification for this change in the overall H-1B analysis. But once again, the industry and overall practice, they've been trending in this direction regardless. End client letters often have a short blurb within the text that expressly states something along the lines of, this so and so role has typically required at least a bachelor's degree in this major or that major at end client company. So, this overall practice isn't all that new.
I guess that's where my confusion then is. Similar to what we talked about last week in addressing the specialty occupation issue, the attempt in redefining it might be more of a clarification of earlier practices rather than a total departure and redefinition altogether. Isn't it the same here? End client companies were already issuing confirming letters that stated how their hiring requirements paralleled to the H-1B staffing company has traditionally done. So is this as big of a deal as people claim it to be?
It's a fair point, but I suppose I personally think it sort of is. It might not have the huge seismic shift that we once thought when this proposed rule was going through the rulemaking process, but even in practice, there have been some unique manifestations in the rule's effect. For example, it seems more common nowadays for USCIS to contact the end client, which will end up receiving the beneficiary services, and expressly ask that end client what it typically requires for so-and-so position. Now, these attempts to contact the end client involved in a consulting or staffing engagement, it isn't new. The State Department has been doing this for years when it comes to consular processing visa applications abroad, and even here in the US. Homeland Security's Fraud Detection and National Security Unit, FDNS for short, their overall mission is to verify the bona fide details of H-1B employment, even after an H-1B petition is already approved. So, contacting the end client on the part of the federal government isn't anything new, but with this expressed change in the overall H-1B rule as it relates to staffing companies, that it's the end client's job requirements that are important and not the staffing companies. This express change, it appears to have sort of emboldened USCIS in making this more of a focus. So the overall frequency of government agents contacting the end client customers over phone, over email, it definitely appears to have ticked up.
But as long as our H-1B staffing company and the end client company are in alignment with the position's job requirements by communicating, would this even be an issue? The two companies should have the same set of job requirements.
In theory, I suppose one would think so, but does this really happen in practice? I suppose that's the question. You have to bear in mind that oftentimes it's contingent on who at the end client company is delivering this news to the USCIS officer. If USCIS contacts the end client company and asks, oh, I can see that an H-1B employee is working at your facility, pursuant to this consulting agreement you have with your vendor, XYZ staffing company, can you verify that this beneficiary is indeed working there? Oh, he is? That's good. But what about the company's job requirements? What have you traditionally used as your baseline minimum job requirements for similar roles at your organization? When such a question is asked, will that person at the end client company be able to repeat verbatim what is stated in the end client letter that got this H-1B petition first approved? Oftentimes those end client letters are prepared and vetted by the HR department or by in-house legal many, many months earlier. But when the FDNS calls our end client company and asks for the manager of our foreign national worker, sure, the manager will be able to confirm that the H-1B foreign national is still working at the end client company, but the manager won't know that a letter was issued by in-house counsel so many months ago that stated the hiring requirements being this or that. Rather, the manager will say that he also has other employees on his team that have decades of work experience along with a prerequisite bachelor's degree, for example. Or, he perhaps might have other employees in similar roles with a bachelor's degree in some unrelated field, but their professional work history sort of makes up for it.
Okay, I follow you. So, in theory, the end client and our H-1B staffing company can attempt to be in alignment with the job requirements, but when the government circles back to verify, that's when things fall apart because we're talking about months, maybe even years after the H-1B was first approved, and also perhaps different people are now in new roles, turnover happens at the end client customer, and these end client companies are massive at times, and communication often goes to the wayside when it comes to this department conveying information to that department.
That's exactly right. And this failure in verifying the H-1B employment as originally attested to, it also seeps into wage level issues. Going back to our end client company manager who receives, a call from FDNS, he verifies that he has other employees with 20 plus years of experience in the role. That's great. But can that be misunderstood by USCIS in their attempts to deconstruct the certified LCA included with the H-1B filing?
What do you mean deconstruct?
Well, if a USCIS officer sees that the end client company employs other similarly situated workers with so many years of experience, but only has this H-1B employee with, let's say, 3 years of related experience, because that is what the staffing company and the end client mutually agreed to for this specific position, would that be deemed suspicious on the part of the officer? Probably. They can conclude that a contradiction exists between what the H-1B paperwork attested to versus what this manager at the end client says to be true in terms of employing similar occupations at that end client company.
It's both fascinating and concerning that something as harmless as an after-the-fact conversation between a manager at the end client and USCIS can really turn things for the worse. But I see your point now that even though these things have been in motion for some time, because now we have a final rule which encourages the government to be more proactive in this regard, that these issues will just become more prevalent in the future.
Right, absolutely.
I do now want to get into the differences between a staffing company versus a consulting company because it's these differences that will compel USCIS in deciding whether the end client's company's job requirements are needed or not. Am I correct?
Yes, yeah, yes, you are. The modernization rule is it's pretty clear that the agency will only look to the end client company's job requirements for the position or similar positions if the agency first determines that the H-1B petitioner is just a staffing company. Now, there are a number of factors involved in making that distinction between staffing versus consulting. And there are arguments both ways, for and against these factors. They can be made all day, but for simplicity's sake, I suppose some things for the audience to keep in mind are one, is the engagement between the end client and the H-1B petitioner a direct client relationship, or are there multiple layers between the two and multiple vendors involved? Secondly, are entire teams being assigned from the H-1B petitioner to the end client, or is it just one professional worker? Because if it's entire teams that include a manager at the H-1B petitioner and team members under him or her, then the argument can certainly be made that it's a consulting arrangement and not a one-off staffing augmentation arrangement. Third, is there some kind of IP or proprietary skill, tool, or technology involved? Because if there is, then the H-1B petitioner can certainly argue that it is deploying more than just human resources to the end client, but that specific project-related tools and non-human resources and instruments are being deployed as well, which will definitely help the consulting company argument. And lastly, even something as relatively minor as an email address, for example, which has the domain name of the H-1B petitioner and not the end client, can serve as a factor in favor of a consulting company finding, because it serves the larger point that the H-1B beneficiary maintains his or her placement in the H-1B company's organization and hierarchy, rather than being grafted into the organizational hierarchy of the end client company with an email domain name that belongs to the end client. These are just a handful of things to look out for, as USCIS will likely use a totality of the circumstances test in concluding whether you as the H-1B employer qualify as a staffing company or not.
And if USCIS concludes that our H-1B petitioner is a staffing company, then this modernization rule tells us that the end client customer's job requirements will matter if the foreign national is to work from the location of the end client.
That's right. And the new edition I-129 form provides a direct means to do that.
What do you mean by that?
Well, I mean, as we touched on last week, the I-129 non-immigrant petition form for H-1Bs, L-1s, and other temporary worker visa classifications, it went through an update. There are some, other changes involved within the form, but the primary one for the purpose of our discussion today is how the form now specifically asks if the work location or work locations is a third-party location. And if you, as the H-1B employer, answer yes to that question, then you will be required to disclose the name of that company at that third-party location.
But wait, Min, doesn't the LCA already do that? The LCA asks for the identity of the secondary location in those instances when the H-1B beneficiary will be working off-site.
That's a fair point, Ariana. I suppose one can argue that this change on the I-129 form is a bit redundant, but regardless, it's there. So, employers should be on notice that USCIS will indeed make this into a bigger issue as part of its enforcement proceedings.
Speaking of enforcement, let's move on to FDNS site visits. You brought them up before as part of USCIS's renewed focus on compliance efforts. What does the new rule have to say about FDNS site visits?
Yeah, the new rule it essentially expands the scope and authority of USCIS to conduct those site visits at the H-1B petitioner's work site, certain neutral locations, and any other place where H-1B work will be performed, including third-party and client locations. The rule, it also specifically mentions how site visits can occur at the private residence of the H-1B worker if the worker is expected to work from home. And if USCIS is, if they're unable to verify certain facts related to the H-1B petition, including scenarios when a third party refuses to cooperate with an inspection request on the part of FDNS, the rule does make it clear that the government has the authority to deny or revoke any petition for H-1B workers performing services at these locations.
I'm sure I'm not alone in saying that this is a pretty general rule and enables USCIS to cast a wide net as part of these enforcement proceedings.
Yeah, you're not wrong. For me personally, more so than redefining what specialty occupation work looks like or having the end client customer's job requirements be the focus, I believe the expansion of FDNS site visits it probably represents the biggest needle mover in terms of what this H-1B modernization rule seeks to achieve. And without a doubt, the biggest issue is a spike in unannounced visits on the part of FDNS.
Unannounced visits? I'm almost afraid to ask, but please clarify.
Well, I mean, most, if not all, FDNS site visits before, they were pre-announced. You have to keep in mind that FDNS is not a new creation. It's always been there. But most times such visits were announced beforehand and often with a list of suggested documents to be made available on the day of the visit. FDNS, they gave this advance notice in order to facilitate the proceedings, to ensure that the parties who needed to be there in order to answer the officer's questions were in fact there, and for better or worse, provided a setting in which the H-1B petitioning company was as prepared as it can be. Whether that site visit occurred at its own facility or the location of its end client. Now, don't get me wrong. Any kind of site visit is nerve-wracking, but knowing in advance that such a visit were to occur, it can at least help ease those nerves and for the company to be as ready as it can be. But what if those visits now happen out of the blue with no advance notice? It seems like these unannounced visits are occurring more frequently as USCIS is looking to change their paradigm to more of a gotcha sort of game. When an officer or even a contractor to the government appears at the doorstep of the H-1B petitioner or the end client and requests to tour the premises, speak with so and so number of folks, review documents that should be available for public inspection and so forth. The stakes have definitely been raised with this new addition to FDNS enforcement proceedings.
It certainly would appear so. As these unannounced site visits now become the new normal for H-1B petitioners, what should employers do, in your opinion, to be best prepared?
That's a great question, Ariana. Preparation and having a standard operating procedure in place, and most importantly, communicating that SOP to others within the company, it sort of reigns paramount. Who cares if a company has the most well-developed, robust SOP that takes into account every FDNS scenario and situation when the receptionist at the front desk does not know what the SOP says and either refuses the FDNS officer from entering or perhaps refers the FDNS officer to a person within the organization who might do more harm than good in terms of conveying the right type of relevant information to FDNS. Every FDNS visit it's different. Granted, there is some overlap here or there. The officer will often ask to see where the H-1B employee sits. They will want to take a look at their workstation. The officer might ask to speak with a supervisor to whom the H-1B employee reports to. The officer might want to see the notices of filing in support of the certified LCA, and perhaps the entire public access file if those files are maintained at the workplace. But the main point is that such visits can take on many different forms. So it's critical for businesses, whether your company is the actual H-1B petitioning employer, or if your business is typically the end client that receives large number of H-1B consultants to your facility. It's critical for all organizations to have a standard operating procedure in place so that everyone, starting from the front desk receptionist to the HR director or C-level executives, they all know whom to contact, where certain documents are located, and what kind of access to give the FDNS officer. An FDNS site visit, it's not a free license for the officer to comb through your entire office space and take photos of everything. Things can be outside of the scope of a site visit, and fishing expeditions for the officer to snoop around, it isn't allowed, and the SOP that your business maintains needs to be clear about that.
Wow, fantastic information. As FDNS site visits ramp up, especially the ones that are unannounced, it's become clear that businesses of all kinds need to have a written policy in place of best practices to follow. So let's move on to other issues found in the H-1B modernization rule. Perhaps some quick hitting takeaways that you can provide us?
Right, absolutely. Most of the other issues addressed in the new rule, they're just a codification of existing USCIS policy and past agency interpretation. The new rule speaks to when H-1B amendments are required, and pretty much adopts matter of Semeo solutions. So it's status quo for that. When amendments are needed, provided that there is a material change in the H-1B employment. The rule also reaffirms the existing USCIS deference policy, stating that USCIS will, for the most part, defer to prior agency decisions involving the same parties and the same underlying facts. So, if we have an H-1B petition that was approved for an employer and employee, and that same employer is looking to file an H-1B extension for that same employee in that same role, the extension will likely be approved, given that USCIS is now instructed to defer to its earlier favorable decision. The one thing, though, that I would add is in terms of this deference policy, the new rule does expand upon it somewhat from previous iterations, in that now deference is given to all I-129 petitions, not just extension of a status request. So it is broader than what it was before.
Which means more predictable results, I would imagine, for both H-1B employers and employees.
That's right. At least that's the hope with codifying this deference policy into a final rule.
But Min, am I right in saying that the agency deference was one of the things that the Trump presidency eliminated previously? Why would Trump 2.0 be any different?
That's certainly a valid question. I suppose one key difference, if I may, is that this deference policy it's now an official rule, so it's no longer just limited to agency practices from before or policy memos. It went through the official rulemaking process, which makes it far more difficult to get rid of, even with a new sitting president who has a history of wanting to make it as challenging as possible for foreign workers and pro-immigration businesses.
Any other takeaways from the new rule?
Well, stepping away just a bit from the from H-1Bs, the final rule also speaks to cap gap relief for individuals on F-1 OPT. The rule essentially provides a longer cap gap protection period that extends from September 30th to as late as April 1st of the following calendar year for eligible F-1 students. Basically, this portion of the rule was added because USCIS delays in adjudicating, H-1B cap petitions when a change of status request was made from F-1 to H-1B. Before, when there was such government delays in adjudicating these cases, F-1 students, they lost their ability to work beyond September 30th. But now with the additional 6 months of employment authorization, the idea is that such, one-off examples of F-1 visa holders losing work authorizations, hopefully those things will be a thing of the past. Also the new H-1B rule speaks to when owners of companies can continue to be the beneficiary of H-1Bs filed on their behalf. And the new rule also gives clarity on when H-1B cap exempt petitions can be filed by certain nonprofit or government research organizations. And lastly, the new rule also provides some relief for H-1B cases that are delayed with lengthy government adjudications. Now, for this position, it is rather limited to a very unique set of circumstances, primarily restricted to USCIS approving the H-1B case only after the full validity period requested has already lapsed. But it does supply some interim relief for H-1B employers and employees who are stuck in such situations.
Wow, all very helpful information, Min. Okay, it seems like the H-1B modernization rule can certainly be viewed as a mixed bag for employers and employees alike, but perhaps you'd agree with me in saying that it does more good than harm for businesses. But with all that said, as our audience knows, we have a new president in office. President Trump is widely viewed as anti-immigration, whether that criticism be fair or unfair. But with that sort of reputation, what's going to happen for the remainder of the year and the next 4 years? Will this new H-1B modernization rule survive in its current form? Can this administration seek to undo everything that has been done before? And what can our audience be on the lookout for?
Right. I get the trepidation. In many ways, Trump 1.0 was definitely eye-opening, and many folks are bracing for something similar or worse with the president's second term. It's difficult to say what the effects, if any, will be with this new H-1B modernization rule. I think it's reasonable to think that the FDNS enforcement policies will stay, and they'll continue to be ramped up. For other aspects of the rule, including the deference policy, how specialty occupation is defined, rules relaxing issues that pertain to H-1B cap exempt employers, entrepreneurs being sponsored for H-1B status, can this administration, can they look to rescind the rule and publish their own rule, their own H-1B rule for notice and comment and eventual publication? Certainly, this administration can do that. But to be honest, I don't know how much of an immediate agenda item that is for the current administration. I'm not going to rule it out altogether in future years, but for the near term and at least through H-1B cap season for this year, it would appear safe for employers and employees to rely on the posted and published new H-1B modernization rule in its current form. Things can certainly change. They can change rather quickly with its president. But for now, it does seem like a safe bet in knowing that this H-1B rule, which has been in the works for well over a year now, is at least here to stay for the short term.
That's good to know. Predictability and being able to forecast what's to come are important things in the immigration space.
Absolutely, Ariana. It's the only way businesses are able to function nowadays in today's fast-moving marketplace.
Absolutely. Well, thank you so much for your time, and that's all we have time for today. Thank you, everyone, for tuning in to part two of this. This is the end of our conversation. Thank you again for joining us. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, send us an email anytime at info@true.com. We'd love to help you out. And make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you again for joining us. Thank you so much, Min. See you next time.
Thank you, Ariana.